What's your name?
I'm Sarah.
Sarah.
Nice to meet you. All right, sir. Any one of these fine areas are for you.
Thank you very much.
Absolutely. Thanks for coming.
I got this one down here. I'm sure everybody else did too. Just make me feel better. Everything that's what it out. Yeah, that's true. That happens.
How you doing, Randy?
You can shoot up that close. So this guy's setting up down there, you can set up close to him. Doesn't matter.
I don't know where he's at. I don't know why he's at. Maybe they Avenue, Michigan. Nice to see you. Yeah, I know. Good. Were you down at the truck this morning?
I'm going to sit behind Howard, make sure he stays away.
Where's your wife?
You were all we had. We were friends.
I want to sit out here.
Mayor, good to see you. Mayor, excuse us. Good evening, members of the audience, candidates, and those folks watching us on Facebook Live and West Virginia Public Television. Welcome to the West Virginia Bar Association Forum of Candidates for Division II, West Virginia Supreme Court of Appeals. Our event tonight is being held at the Culture Center near the State Capitol building here in Charleston, West Virginia. I would like to start by asking Mayor Danny Jones of the City of Charleston to come up and say a few words of welcome to our candidates and our guests. Mayor Jones?
Thank you. Thank you. A very few words, because it's not about me tonight. It's about a fine bunch of candidates to sit on our Supreme Court, and these are a good bunch of people. We're very excited to have it here in Charleston, and people, we hope people tune in and pay attention and learn from this great group of people, great bunch of candidates. Harvey, thank you for your association and to have it here and to be personally involved the way you have. And my radio station's represented, and I'm happy about that, so thank you.
Thank you, Mayor.
Thank you.
Well, our association is the West Virginia Bar Association. It was formed in 1886. We are the oldest and largest voluntary bar group in the state of West Virginia, and actually the sixth oldest in the United States. Our purpose being to promote the intellectual and social interests of the legal community and, more importantly, collegiality among and respect for the bench and bar. We would like to thank particularly, and you can see them named on the backboard here, our title sponsors for tonight, the Kanawha County Bar Association, Frost Brown Todd LLC Attorneys, West Virginia Radio Corporation Metro News, the West Virginia Press Association Services Foundation, and you can see our other sponsors listed in the program. Without all of their assistance, programs like this could not have and would not have been possible. A particular thanks to West Virginia Public Television. Our proceeding is being broadcast live at this moment on any number of cable stations around the state. This program will be archived on the public television website. We are also broadcasting live on Facebook through the West Virginia Bar Association website. It will be archived there as well, so anyone who wants to refer back to this proceeding between now and Election Day is free to do so. The West Virginia State Bar has approved this proceeding for 2 hours of continuing legal education, 1/2 hour of which counts towards a credit in ethics. Those attorneys who are here in person who may not have yet provided their bar information can do so before you leave. If you are watching live or if you stream later on Facebook or the archive on public television, you can do that and self-report and receive the credit even if you're not here in person. Tonight we have the candidates for Division 2. This is a 6-year unexpired term on the court. The term to which one of these 10 folks will be elected commences when the special election of November 6 results are certified and ends on December 31, 2024. This is the seat that became available when Justice Robin Davis retired on August the 14th of this year. I would ask each candidate to start to acknowledge by raising their hand as I call their name so their identity can be generally known to everyone in the hall. First is the Honorable Jim Douglas, who is a family court judge of Kanawha County, West Virginia. Robert J. Frank of Greenbrier County. The Honorable Evan Jenkins, Justice, West Virginia Supreme Court of Appeals, Cabell County. Jeffrey Kessler, former Senate President of the state of West Virginia, Marshall County. Brendan Long from Putnam County. William Swartz of Kanawha County. Marty Sheehan of Ohio County, Denise Renee Smith of Kanawha County, and the Honorable William Stewart Thompson, Judge of the 25th Judicial Circuit, Boone and Lincoln Counties in West Virginia. As you can see, we have an array of candidates from all around the state. Questioning of our candidates tonight will be by a panel of 2, the first of whom is Dean Gregory Bowman. Dean Bowman is the William H. Mayer Jr. Dean and Professor of Law at the West Virginia University College of Law, a position he has held since 2015. The other examiner or moderator will be Jeff Jenkins, who is the news director, statewide news director for West Virginia Metro News, this state's largest statewide news broadcast agency. He is also the chief capital correspondent for Metro News, covering all major political events in West Virginia. Our format will be as follows. Each candidate will have a period of 3 minutes for an introductory statement. The order of presentation will be by random selection by our panel from a receptacle in which each candidate has a name on a note card. The topic of the opening statement is something dictated by the association, and that we are asking the candidate to self-assess, why am I qualified to serve as a justice of the West Virginia Supreme Court of Appeals? After those remarks conclude, there will be approximately an hour or an hour and 10 minutes of questions by the panel to the candidates. The panel members will select in alternate order to whom they wish to direct a question. None of these questions have been screened or disclosed to any candidate. They have not been reviewed by the association or anyone else, and that will continue in turn as the candidates are addressed, as I say, for about an hour and 10 minutes, with the candidate each having 2 minutes to formulate and give an answer to the question. After that question and answer period concludes, each candidate will have 2 additional minutes to state their final position, their position to the voters of this state on why they should be elected to the Division II seat on the Supreme Court. Candidates' time limits will be strictly enforced. We have 2 timekeepers in the front. You'll be shown when you have 60 seconds left, 30 seconds left, 15 seconds left, and then a stop sign will show and a gavel will sound, and you are expected to conclude your remarks immediately. We do ask that the answers be responsive to the question. We ask those in the audience that there be no applause or audible outbursts in favor of or opposition to any candidate during the course of these proceedings. At the end of the forum, there will be an additional 1 hour of a reception in the Great Hall where the candidates will be present to meet and greet those who are present. There will be refreshments served. We look forward to a lively exchange. We certainly had a lively exchange on Monday when we were dealing with Division I candidates. So at this time, without further ado, we'd ask our panel of Dean Bowman and Mr. Jenkins to come forward and draw the first person who will make a 3-minute presentation. Thank you very much.
Keep feeling this podium vibrate.
I'll let you do the honors.
So our first opening statement will come from Denise Smith.
Good afternoon, everyone. My name is Denise Smith, and I'm running for Division II. I'm running to be the new face of justice. My experience is that I'm an attorney since 1996. I am a West Virginia native. I went to WVU undergrad and WVU Law School. My experience is both as a plaintiff and as a defense attorney in the area of employment and labor law and also workplace safety law. I've also represented the Huntington Human Relations Commission. I've done work for the WVAFT. I've also been an administrative law judge for the Unemployment Compensation Division. I've been a legislative attorney for the House Judiciary Committee and the House Constitutional Revisions Committee. So I understand the constitutional rules that apply to lawmaking and how those rules will be constructed and construed when on appeal. I believe that I am the best candidate in this race because you have to go back to the canon of judicial conduct. And the most important rule in the canon of judicial conduct is to be fair and impartial. The word impartial is actually found 11 times in the rules of judicial conduct. And when we as attorneys look at people who are running for the Supreme Court, we always want to know if they're going to be biased or they're going to give our clients a fair hearing. And how do you do that? You look at their background. Plaintiffs' attorneys are always suspicious of people that have exclusively defense experience. Same with defense attorneys who have a suspicion with plaintiffs' attorneys. Where I have represented both sides and also been an administrative law judge, I understand the importance of looking at all of the information. I do not filter facts through a worldview. I look for the truth first, the answer under the law first, and I believe that makes me gives me the ability to be unbiased and impartial. Further, I have the character and I have the temperament of being a judge. I am not egotistical. I have no ethical violations. I'm someone who listens rather than talks. I think rather than react. I understand and honor the role of a judge being solely focused on the law and on the facts and on the Constitution, showing no favoritism or bias to any party. So I believe that my character makes me uniquely qualified and my background makes me uniquely qualified for this race. I believe we are at a crossroads right now with our Supreme Court, and it is vitally important that we protect the integrity of the court and make sure that we protect the court from political influence and from any factors that would lead the public to believe that they cannot have a fair and impartial hearing before the court, because that is a vital aspect of our democracy. And when you have loss of a trust in this, you will have loss of a faith in democracy. Thank you very much.
Next, we will hear from William Thompson.
Hello, my name is Judge William Thompson. I'm the circuit judge in Boone and Lincoln counties. I've been a circuit judge there since 2007. Before that, I was a practicing attorney with the law firm of Cook & Cook, did a wide variety of cases. I've been recognized nationally for both my work with drug courts and also my work with children. Not only do I think I'm qualified to serve on the Supreme Court, I think I'm the most qualified to serve on the Supreme Court out of these candidates. I'm the only circuit court judge in the race. That's very important. Let me tell you why that's important. First of all, I have an experience in a wider variety of cases as anybody in this race. I've handled every type of case that would appear before the Supreme Court. I've handled on a trial court level. I understand those type of cases, whether they be abuse and neglect cases, whether they be criminal cases, whether they be civil cases, whether they be complex litigation cases, whether they be criminal cases, guardianship cases. Everything that could possibly appear in front of the Supreme Court, I've already handled as a circuit court judge. And let me tell you why it's even more important than experience. I have the experience of thinking like a judge, and let me explain what I mean by that. It's much different when I took the bench to understand how to hear both sides of an argument, hear the facts of an argument, and rule on an argument. And that might sound simple. It's not as simple as it sounds. Justice Walker recently testified at her impeachment trial that it took her more than a year to think like a judge. We don't have time for a learning curve in our Supreme Court. We have a Supreme Court that's in crisis. We need people who can hit the ground running. We need people who have experience to do this. We need people who know what they're doing. I mean, this is an important position. This is one of the most important positions in state government. And to put people up there with little to no judicial experience is very scary. So that's why I think I'm the most qualified candidate. The final reason why I think I'm the most qualified candidate really has not a lot to do with legal ability, judicial reasoning, or anything like that. The final reason is that I care. I care about my state. I care about the people of this state. I care about the children of this state. I am running because I care. This is not something I'm running to get a promotion or anything of that nature. I love the current job I have. And I've been able to help a lot of people that way. But I want people to know this. I'm running because I care about the state, and I care about the people of this state, and that's why not only do I think I'm qualified to do this job, I think I'm the most qualified to do this job.
And then we remind all the candidates to be friends with your microphone, okay? Make sure that's close to you. All right, next up is Jim Douglas.
Thank you. I'm Jim Douglas. I've been a member of the bar for 42 years. I've had 39 and a half years as a practicing attorney in all aspects of the law, but the last 28 uninterrupted years, I've been a divorce lawyer, family lawyer, and done everything in family law. I'm currently a family court judge. Now, why is that important? Let me bore you. Nationally, in 2016, there were 250,000 state court appeals. 50% of those were domestic relations matters. There's one divorce for every 200 citizens within the United States. There's one divorce every 13 seconds, or 277 every hour. The average wedding reception, most of you have gone through, it's 5 hours. There are 1,385 divorces granted across the United States during one wedding reception. First-time marriages last, in terms of divorce rates, is about 50%. Second-term marriages, the divorce rates are about 60%. The average first marriage lasts 8 years. The red states, if you live in a red state, you're 27% more likely to have a divorce than in a blue state, and we're a red state. 50%, and this is the most sobering statistic, 50% of all children in their lifetime, in their minority, will be subjected to a divorce in their family somewhere. West Virginia statistics are even more haunting. West Virginia has the second highest divorce rate, second only to Nevada, and tied with Arkansas. Don't ask me why Arkansas. In 2015, there were around a little over 1,000 cases filed in the West Virginia Supreme Court of Appeals. In the civil cases, 48% of those were domestic relations. In 2016, there was just under 1,000 cases filed, and 50% of the civil cases were family law or domestic relations cases. In 2016, all cases filed in the 55 county circuit courts equaled 52% in domestic relations. Now, I was here Monday night, And I didn't come to spy or figure out what the questions are going to be. I came because I didn't know all of them in Division I that are running for the Supreme Court on the 2-year term. But what bothered me was not one word was said about divorce, custody, or allocation. There was never one reference to guardians ad litem or their proper funding by the Supreme Court, which was recently cut in the fall of 17. There was not a breath of a word about LGBT rights. There was not anything said, to my chagrin, about domestic violence. Now, yes, there was things about abuse and neglect, but that was in the context of how heavy a load the circuit judges had. Also, there was questions about the opioid crisis and recusals. But not one word about families and children. Why? Are children not more important than anything else? Thank you.
Next, we will hear from Robert Frank.
Good evening. First, I'd like to thank the West Virginia Bar Association and Dean Bowman and Mr. Jenkins. I live in Lewisburg with my wife and my daughter and my mother-in-law and an overly energetic sheepdog. And for the past 28 years, I've been representing ordinary people facing extraordinary challenges. In those 28 years, I've had uniformly good relationships with my opposing counsel, including Judge Douglas, with opposing parties, and with the bench. We chose to move to West Virginia. We chose it mostly because of the people and because it's a beautiful place. But when we got here in 2006, shortly after we were here, there was a problem with the Supreme Court. Apparently there were justices who would go on vacation with parties in front of them and not recuse themselves. There were millions of dollars put into campaigns by parties that were appearing before the court without recusal. And as an attorney appearing in other jurisdictions, I had to respond to that. I began to take up for the West Virginia Supreme Court and for the state of West Virginia, which is my wife and I's adopted home and my daughter's natural home. And when this current crisis came, again, we were trying to defend the indefensible. Our system of justice requires that the people have confidence in the courts. Our system of justice requires that society can rely on them to be fair and open. Our system of justice requires that the people who serve on it be qualified. You know, one of the things that all of us will swear to do if we're given the honor of having this position is to, serve and protect the Constitution. So the real question is, how many people on this panel have really litigated constitutional cases? I've litigated First Amendment cases. I've litigated First Amendment cases for religious freedom, First Amendment cases for Second Amendment rights. I've litigated for LGBTQ folks who've been abused by governmental authority. And I've advocated for churches on issues of transgender bathrooms so that they're fair to people of faith and the LGBT community. I've also done family law cases. I've done many family law cases, many cases involving children, and I've served on the CYAC, the Child and Youth Advocacy Center, which advocates for children. I've also done pharmaceutical litigation, including against Purdue Pharma for the prescription drug OxyContin. I've done easement cases. I've done property boundary cases. I've done every kind of injury case imaginable, and it's that type of breadth and experience that we need on the court, and that's why I'm running. I love our practice. I love the court. We need someone to serve. I'm willing to serve. Thank you.
Next up is Jeff Kessler.
Thank you, Jeff. I'm Jeff Kessler. I'm going to tell you a little bit who I am, and then I'm going to tell you why I'm qualified. Who am I? I'm 62 years old. I have a married, live in Glendale, Marshall County, West Virginia. I have 5 kids, ages 28, 26, 13, 10, and 4. You did hear that right, a 4-year-old boy. Just started preschool. My daughter just started her first job as a teacher and after graduating, getting her master's in early childhood education. I'm the grandson of Russian immigrants who come over from Russia. My mom was raised in a Hitchman Row coal mine home. They didn't have a whole heck of a lot of much in terms of money or whatever, and they're growing up. My dad was the son of a woman who his dad was the chief of police in the town and died when he was 5 years old, and he was raised by a single mom. My parents, though, they both told me one thing as you grow up: don't ever look down your nose at anyone, but don't ever let anyone look down their nose at you. You always treat everyone equally, fairly, and with respect. And I've tried to do that my entire life. I was the first one in my family to ever go to not only college, but then to law school. I worked my way through college work study. I was a garbage man, taking out the trash at Boner and Curtis Hall, West Liberty State College at the time. You know, it was the way to get through. My mother wanted us to go to college, wanted me to go to law school. She took a job as a bank teller. She was proud when I got admitted to WVU Law School. Unfortunately, she never saw me graduate. She died, unfortunately, at the age 47 of breast cancer, the night before my first law school final. It was tough. I didn't do real well that first semester. Never ended up on the honor roll or order of the COI for any of that stuff, but I made it through. And I got through law school, went back to Moundsville and opened a law practice where I've been practicing law as a small town lawyer for the last 37 years. What do? I take care of people and I solve their problems. That's what good lawyers do, and that's what I've been doing. Adoptions, domestic relations, contract disputes, real estate, deeds, wills, elder law, workers' comp, car wrecks, med-mal, small business formation. You say it, I've done it. I've taken care of folks in my community from cradle to grave. Then I got into my other life in politics and served as a state senator and Senate president, where I actually ran the Senate and ran from a snotty-nosed little kid in McMecken, West Virginia, to the second most powerful position in the state as Senate president and lieutenant governor of the state. I've written the budgets for the state. I've helped run the state. The state court is in crisis. I've known how to fix crises in the past. I've done it, and my experience in the legislature has shown that I can do that through medical malpractice, workers' compensation crisis, and even the transition after Senator Byrd died. I stepped up and solved those issues, and we'll resolve the crisis in the court system as well.
Now we will hear from Jim O'Brien. We already did that one? He's not here, that's right. I'm sorry. That's my bad. How about Evan Jenkins?
Great, thank you very much. Jeff leaned over to me when you introduced Jeff Jenkins. He says, "Is that your cousin?" And I said, "No, that's my brother." He said, "Oh, we're in trouble tonight." No, just full disclosure, Jeff Jenkins is no relation to me, so you're safe tonight, Jeff. After hearing the good judge's comments, I want to start off by saying I love my wife. We've been married for 27 years and 3 children. No divorces planned at our home. Thank you so much to the Bar Association. I really appreciate the opportunity to be here, and those that are watching and those that are here. You've heard the word crisis mentioned twice. Let me first start with a little bit of my background. My great-great-grandfather was Fire Boss Jenkins. He died in a coal mine explosion. My grandfather was a lawyer, started practicing about 90 years ago in Huntington, West Virginia. My father practiced law, became the Jenkins Fenstermaker firm, and 30 years ago, I started practicing law in West Virginia, admitted to the bar, and active involvement in a number of litigation, tried cases in Cabell County Circuit Court, handled cases before the West Virginia Supreme Court, administrative law, extensive law experience. But why am I somewhat unique in this panel? Well, I've run for office a number of times, and I think we need somebody on the Supreme Court who actually understands what the people are thinking, haven't had their nose in the book or in the courtroom their entire life. You know, I've stood for election. I've listened to voters. I've been connected to the people, listening, understanding their needs. I think that's part of the problem of the court that has been out of touch with what the people of West Virginia want and expect and their priorities. So I welcome the opportunity to serve the people of West Virginia on the West Virginia Supreme Court of Appeals. You know, I went through the process of the Judicial Vacancy Advisory Committee. They gave me the designation, amongst some others, as the best qualified. They conducted interviews. They looked at the resume. They took in references. And I'm honored to have been designated best qualified in the list submitted to the governor. And the governor did me the honor of selecting me to fill the vacancy. I've been on the court just 3 weeks. I hope to be part of the solution. I certainly am not going to be part of the problem. So we are talking about reforming the court, bringing honesty, integrity, accountability, transparency back to the work of the court. And I look forward to this discussion tonight to talk about the things that we are already doing. And I hope that the voters will give me the opportunity on November 6th to continue my work, to transform the court and bring it to the type of institution every West Virginian deserves.
Up next, we have William Schwartz.
I'm Bill Schwartz. First of all, thank you for having us. I'm Bill Schwartz, and I live right here in Charleston, West Virginia. I'm 58 years old. I have 2 boys. I've been married 26 years. I have 2 boys, one at Marshall University and one at Capitol High School. Like me, both boys were athletes. I'm a graduate of Washington and Lee University School of Law, where I earned my JD. While at W&L, I was justice on the moot court board. For non-lawyers, that means I was one of the top advocates at that school. I was also selected while at W&L to be coach of the mock trial team. And I took them to the regional championship, where we won the regional championship and went to the national championship for the national trial competition. I wanted to be a trial lawyer, and I prepared myself right from law school to do that. While at St. John's University, I earned my bachelor's degree on academic and athletic scholarships. I was a 2-time Big East medalist, and the only reason I mention that is I don't think people should vote for me because I'm an athlete, but because I work hard. I work hard at everything I've done. I've been rated as top 100 lawyer by the National Trial Lawyers, a litigation star by Benchmark Litigation, the President's Award by the Association of Justice because of my service to my profession. I am committed to my clients, and I am committed to the law. Now, I got into this because I went to my 30th reunion at Washington Lee, and some guy from Texas pointed at me back in April and said, "Hey, Bill," or Schwartz, "how many justices are going to get indicted this year?" And that cut through me like a knife. It was one of the most embarrassing moments in my life. And I knew what he meant. He meant, "Bill Schwartz, you're not really a lawyer from a real state with a real court." And that's a guy from Texas, and they knew that in April. So a week later, a couple of friends of mine came back to me and said, "Would you consider running for court?" I said, "I've never run for a thing in my life, but you called me at the right time." And that's why I got into this. I was at Shiloh Baptist Church about a week ago, talking about voter rights, and the pastor there said to his congregation, "Lady Justice isn't blind, she peeks." And we got to change that. We got to change that attitude. And how do we change that? 3 ways. Predictability, consistent results, no matter who's in front of you. Recusal, remove yourself if there's even the appearance of impropriety. And finally, taxpayer money. Respect the taxpayer money. And I think, and I'll get to this later, the most important thing, you've got to be in charge of that court administrator. You have to control. Rule on your cases, rule with fairness, but control that court administrator. And I hope to earn your right. I hope to earn the vote, and I hope to be able to serve you.
And next we will hear from Brendan Long.
I'm Brendan Long. I'm asking for your vote as a candidate for the Supreme Court in West Virginia. I want to thank the West Virginia Bar Association for hosting this forum. Those that are watching on TV, on the internet, and those that are in the audience, thank you for coming. I also want to thank my wife. She's been my wife for 9.5 years. We met in church. We live in Putnam County, and we attend church here in Mount Calvary Baptist Church here in Charleston. These are dark times for our Supreme Court here in West Virginia. I want to restore honesty, integrity, fiscal responsibility, and put some transparency back into the Supreme Court. If elected by the voters of West Virginia, I will be a humble public servant. I have an undergraduate degree in accounting and finance. I put myself through law school through the evening program at Duquesne Law School in Pittsburgh. And doing that, I was able to also be an administrator at the University of Pittsburgh while I was there. I've been a summer intern with the Supreme Court in Pennsylvania. I've also been a law clerk for Judge Duke Bloom here in Kanawha County, and also assistant prosecutor in Kanawha County. Before opening my offices, which I have now as long law offices in Putnam County. As a former administrator and current practitioner, I've had an opportunity to look at budgets, review budgets, put in sound fiscal practices, and manage those accounts and the money that's in them. Throughout my legal career, I've dealt with the opioid crisis that we have here in West Virginia. I've been in both the prosecution, defense of cases, both criminal, and I've also had civil cases as well. I've been a guardian ad litem for the family court. I've also been a representative as a counselor for those in the juvenile system as well. So I'm trying to do what's in the children's best interest as well in West Virginia. I also volunteer in Putnam County's adult drug court, and I'm also on the criminal justice board in Putnam County as well. Again, I ask for your vote. I want to be an impartial, open-minded, and fair judge, and I'm asking for your vote. Thank you.
And the final opening statement goes to Marty Sheehan.
Oh, thank you. I thought I was being left out, but there we go. I'm running because I started thinking about, was I qualified? The answer is, I've had a federal background check every 5 years since 1984. That's a long time. My first job was as an assistant U.S. attorney. That requires an FBI background check. I did pretty well there. When I left in 1990, we had prosecuted a significant organized crime figure in Wheeling. I achieved a Special Achievement Award from the Department of Justice, letter of commendation from the Director of the FBI. 2015, to show you how things change, I was named a top 10 criminal defense lawyer here in the state by the National Academy of Criminal Defense Lawyers. I've been a recognized expert on the standard of care in habeas corpus cases, whether an attorney did an appropriate job. In Ohio, Marshall, Wetzel, Marion, and Kanawha counties. I've defended cases with 20 homicide victims. I've been involved in several cases with insanity issues. I have established a fairly significant precedent on felony murder, a case called State X. Rel. Davis versus Fox. And if I had just achieved in those criminal areas, I think I might be suitable for the court. But I've also become a nationally known person in the area of bankruptcy law. I was named a super lawyer in 2009, the editor, the secretary, treasurer, vice president, president, and all the other offices of the National Association of Bankruptcy Trustees. I've been active in their amicus practice. I've written briefs at the 1st, 3rd, 4th, and 8th Circuit. At the U.S. Supreme Court, Justice Thomas cited a brief I'd written favorably in some of the footnotes in the majority opinion in Schwab versus Riley. Spent 15 years on the Wheeling Board of Zoning Appeals. I've had an undergraduate degree in economics. I teach adult Sunday school at the church I attend, and I was recommended, this I thought was important, through the judicial selection panel, I sought recommendations from former justices of the Supreme Court. I'd be happy to say that Justice Neely, Justice Recht, and Justice McCuskey all wrote me letters. I really feel that those are people who know what the job is about. They know who I am. They know those things that you want to know as an attorney. We've heard people talk about integrity, but the way you develop integrity in a court is you develop integrity in the people, and I think that the list of credentials that I've brought to you reflect that. I've been married for 41 years to a woman I'm lucky puts up with me. We have 3 kids. They're all WVU graduate. Sorry, the youngest one has not graduated yet, but they're all WVU people. I've taught at the law school, and those are the categories of things that we need to do. Justices write opinions, and I know how to do that. Thank you very much. And thank you for the opening comments. Now we're going to start the period of questioning. Let me ask the candidates one more. Just pull your microphones back towards you because we want to be sure that we get everything on mic. The first question in the rotation will be posed by Dean Bowman. Dean.
Thank you. My first question is for Mr. Douglas. Mr. Douglas, you talked in your opening statement about family court, family law issues, and also issues pertaining to diversity and inclusion. And my question is about your views on whether the courts in West Virginia and the Supreme Court deal effectively with things such as implicit race, gender, socioeconomic, or other biases.
I'm sorry, could you repeat the last of that question? I didn't hear it.
What are your views on whether the courts in West Virginia as a whole deal effectively with matters of implicit race, gender, socioeconomic, or other types of bias?
Well, I think starting first with the socioeconomic, it bothers me that there's not adequate funding for guardians ad litem from the Supreme Court. And my position is that I remember in October of 2017, they advised all the family court judges that we had to cut back, number one, on our guardian ad litem appointments. They already had a $3,000 cap. They were trying to give us, compel us to shift payment to individuals, some that were indigent, some that were not. And in the meantime, they were making all these expenditures. So no, I don't think so. The other thing is that we were also advised that period of time, and it's still the case as far as I know, that reconciliation counseling was cut out totally. And in my mind, that is part of avoiding future litigation among domestic relations litigants. I think also that when you look at what else the Supreme Court is, I think a lot of times it has an attitude that family court and family court judges are the embarrassment of the state when they're actually vital for the state. I gave you those statistics, and when you look at also the situation too about the appellate procedure, a lot of times we have to. We're being appealed through circuit judges, with all due respect to my good friend, Judge Thompson. A lot of times circuit judges don't have any experience in family law. Then it's kicked up to the Supreme Court, and right now there's just one justice left on the Supreme Court that's had any family law experience at all. So I think that, no, the Supreme Court's not responsible for that. With regard to the LGBT, I remember I had the first case that was successful, an LGBT custody case in 2005, and I remember that the word lesbian, the word LGBT, or the abbreviation, was not used. Now I'm told I'm the only family court judge that does LGBT weddings, and I don't think that's right. I think we all should be compelled. Thank you.
Next question is for Denise Smith. In a recent edition of the Metro News Dominion Post West Virginia poll, only 4% of likely voters surveyed expressed a great deal of trust in the Supreme Court of the state of West Virginia, and just 12% expressed quite a lot of confidence in the court. 21% said they had no confidence at all. Almost every candidate that we've heard now for 2 nights in their opening statements have said they wanted to restore the confidence and the trust in the court. So for me, define confidence and trust and give me specifics on how you would restore that.
Well, I think the obvious issues with the confidence and trust in the court started off with the lavish spending and the appearance that some of the justices were utilizing public funds for selfish purposes. But when I'm traveling around the state, I'm seeing a big issue in trust and confidence, in that a lot of people believe that the court is a partisan body, and a lot of people doubt that they can have a fair and impartial judge. And this issue is very detrimental to our judiciary. It is very damaging to the court system. Obviously, one of the easy fix is the financial issues. We can all have transparency with regard to the budget. We can all prioritize the budget, have stricter controls over the budget. But it's much harder to fix whenever the people start to believe that the court is a political body. And the legislature took great steps steps towards rectifying that by making the elections nonpartisan. I agree with that. I think that made great strides. However, now, due to the actions of the legislature, some people thought that was a political ploy, that it was politically motivated. And then I'm hearing from other people that they feared that this was an opportunity for the legislature to use the court as their personal playground so that the governor could put people on the court that were his team players. So we have to do a lot of outreach to the people to explain the judicial rules of conduct and the canon. And I think we need to revisit the judicial rules of conduct with regard to recusal, and I think we need to revisit them with regard to campaign activities to determine whether there can be any strengthening of those rules so that we can eliminate the appearance of bias. I think recusal would go a long way to strengthen those rules.
This question is from Mr. Jenkins. Mr. Jenkins, you have experience in the legislative branch. Given the importance of the principle of separation of powers in our system of government, how will you approach issues of conflict between the legislative, the executive, and the judicial branch?
Well, thank you, Dean, very much, and I appreciate that. You know, we do have 3 separate but equal branches of government. And, you know, we all go back to our government class in civics, and we talk about how there's supposed to be checks and balances. I think the fact that I have got legislative experience, actually crafting legislation, understanding that process, both at the state level and now at the federal level. It was fascinating just yesterday at the State Judicial Conference of all the circuit judges in West Virginia, they're talking about implementation of a federal law that I was in Congress just a number of months ago. So the judges are being educated about laws that are passed and how to implement those. I bring this wealth of experience and understanding of what goes into that part of the process, but I am absolutely perfectly clear when I put my hand on the Bible and raised my right hand just 3 weeks ago to uphold the Constitution and respecting the separate but equal branches of government. It is important that I am not in a capacity as an advocate. I am not advocating for the passage of a bill. In fact, we are prohibited from speaking about anything that might come before the court. So as a jurist, as somebody who is now serving on our West Virginia Supreme Court of Appeals, I absolutely understand the importance of that separation and to make sure that I am looking at every piece of legislation or any case or any matter that comes before me in an absolutely impartial way, making sure everybody has equal access and making sure that we interpret the law appropriately as directed by our Constitution.
Next question is for Robert Frank. Should the court accept more cases for oral arguments? Should there be more oral arguments before the court?
The court should absolutely accept more cases for oral argument. If you go back over the docket sheets for the court for the past year, there were 41 days of argument in the entirety of 2018. 41 days of argument. If you were to tell a circuit judge or a family court judge that they would only have 41 days where they were hearing argument and dealing with arguments in front of them, they'd simply laugh at you, because that's not realistic. You know, there's been much talk about an intermediate court of appeals. Well, that's a very expensive proposition. I've seen estimates of up to $30 million for that. You don't need an intermediate court of appeals, at least not in an atmosphere of very restricted resources, when you have a Supreme Court that's only hearing argument 41 days out of the year. The circuit courts work very hard. The family courts work very hard. The Supreme Court needs to work just as hard. Now, a Supreme Court has much time reading briefs. They have a lot of time where they go into conference and they discuss things. But you know, circuit court judges read very similar briefs. Family court judges, when they practice at a high level, are reading those same types of briefs. It really is unfortunate, and it's part of what leads to the lack of confidence when we don't have an ability to go in and have our day in court. Both the federal Constitution and the West Virginia Constitution guarantee every person effective access to the courts. Not just access, but effective access. And that means being heard. And if our court takes more days of argument, more people will get heard, confidence will be restored.
My next question is for Mr. Kessler.
Thank you.
Mr. Kessler, as you know, judicial temperament has been a subject of national discussion in recent weeks. How would you describe your judicial temperament?
Well, I think my judicial temperament's the exact same as it is in my real life and practice of law. As I mentioned earlier, as my mother said, no one looks down their nose at you. You don't look down your nose at anyone. You treat everyone with equality, with dignity and respect and fairness. I treat all clients like that. That's why they keep coming back. You know, litigation in the courtroom is often winners and losers. But you know, not everyone's going to win. 50% is going to win, 50% is going to lose. But everybody that walks in that courtroom should at least feel that they've been heard, they've been treated fairly, and they've been treated with dignity and respect. That's what the court and every good lawyer does, and what every good judge should do is to treat all litigants fairly. I've prided myself on that. I've been open, you listen, you ask questions, and then you resolve the case based on the facts and the law. And you do that regularly, continuously, and religiously. And as you do, then there's predictability with the court. You know, I don't know that anyone should be judged differently because of the color of their skin, their the religion they practice, who they love at night, or what their sexual orientation may be. That should have no bearing whatsoever. How much money or political influence you have should have absolutely no bearing on the outcome of the case. I can assure you, if elected, every single litigant, regardless of who you are, how much you got, or who you're connected to, will get treated fairly, and will be no distinction between anyone that walks in my courtroom.
This is for William Thompson. Considering the many issues the state faces, what should be the financial priorities of the court over the next few years?
The state's facing a lot of critical issues. I think one of the most critical issues the state is facing right now is the opioid and drug epidemic. It is actually destroying our families, it's destroying our states, it's destroying our communities. One of the biggest reasons I'm running is because I am known, I've run several types of drug courts and been recognized for those. Our Supreme Court, while I'm running those programs, are giving me emails and letters and telling me that I need to lay people off, that that's not an important enough position. And frankly, that made me very angry, especially when it came out with all the expenditures that were made by the court. I think another important expenditure we need to make is we need to create family drug courts in this state. We have a foster care crisis that is overwhelming. I think the latest numbers are showing over 7,000 kids in foster care. I think the number is actually much higher than that, because those are only the kids who are actually as part of a court order. How many kids do you know in your community are being raised by grandparents or aunt and uncles because their parents can't take care of them? So I think one of the highest financial priorities we need in this state is to create family drug courts so we can work on creating safer places for children to reside, give an opportunity to have the families rebuilt, give the kids a chance, give the kids a chance at a future. The opioid epidemic, the drug epidemic, it's taking away not only children's future, but it's taking away our state's future as well. That, I think, should be our highest priority.
Mr. Long, my next question is for you. You mentioned in your opening remarks, you described these as dark times, and you advocated for honesty, integrity, transparency, and accountability. And my question for you, in light of that, is I would like for you to describe for us a situation in which you had to support a legal position that conflicted with your personal beliefs. How did you handle that?
I was going to say I've had to represent, especially with criminal cases where you're representing somebody that, I mean, you may not, the crimes that are committed are sometimes very, they're just not very popular, and they're pretty bad crimes. But you have to sit down, you have to treat that person as somebody that needs representation. You have to look at what their defenses are, and you treat them as a zealous advocate. You're putting forth your best foot forward with them, and even though you may not like the crime that has been committed, you still have to go forward and do your best for them as a client. And I think those are probably your toughest cases as an attorney as far as criminal law. So I think making sure that you're fair and that you're doing your best as their advocate in the court system, and making sure that they're getting their fair trial, making sure that they have the evidence in front of them, making sure that they know what their defenses are, and then making sure that they know you're there to support them, whether they're pleading or whether they're going to go forward with the jury trial. Thank you.
A question for Bill Schwartz. And it was mentioned here in some of the opening statements about an intermediate court. So do you believe there should be an intermediate court of appeals in West Virginia so that more cases on appeal can get a full hearing? Why or why not?
No. I don't believe there should be intermediate court in the state of West Virginia. We're a tiny little state. As has been pointed out, the court can probably hear more cases as it is right now. I believe, and I know what it's like to represent a family where the husband's dying, and there's only a limited time to get this thing resolved. And the longer it drags on, the less likely he'll live. And a lot of clients that come to me, the clock is running, and my job is to take care of them. And I believe an intermediate court does one thing and one thing only: it delays justice. In a state like this, New York, California, maybe it's different. A state our size, with the amount of arguments that are being heard, intermediate court, the expense, the time, the effort put forth by the lawyers, and the money spent by taxpayers. We're already talking about taxpayer money. I don't think we can afford it. I don't think we need it, and I think it hurts people.
Mr. Sheehan.
Yes, sir.
You spoke in your opening statement about many dimensions of your career. What particular outcome are you most proud of in your career, and what does that tell us about what kind of Supreme Court justice you would be?
Actually, I'm going to tell you a story about sitting on the Board of Zoning Appeals. And there was a local college, wanted to build a parking lot. We have a requirement that you put in trees as part of the parking lot. They came and they asked to not have trees in the parking lot. Now, some reasons that you want to do that, but they said we couldn't afford them. And that was the other answer. And the city was adamant that it would get the trees, preserve some green space. And I started asking questions about what the budget was and what kind of fiscal year it was. And I thought the attorney for the city was going to lose her mind. But ultimately, what we ended up figuring out was that the parking lot didn't have to be finished within 18 months. We had the opportunity to take 2 fiscal years to solve the problem. The college had the ability to raise the money and put in the trees during the 2nd year. And so it's one of those solutions, and that's what we did. We said you have 2 years to finish the parking lot, but you have to put in the trees, and everybody went away happy. And that, and I heard Mr. Kessler say there's often a winner and a loser in court, but that's the kind of solution where everybody wins. And it just takes a little bit of more creativity and a little bit more of understanding of what all the issues are in order to get that kind of solution. So to me, yes, there are winners and losers, and I know a lot about rules, and I know a lot about precision, and I can tell you lots of stuff about procedure. But the truth is, the law should be used to achieve good outcomes, successful solutions to problems, because ultimately that's what the law is about. Thank you.
This question is for Jeff Kessler. Some would say that once some get to the upper floors of the east wing of the state capitol, they change. And there's some entitlement there, or at least that maybe has been the attitude. How, if elected, would you stay grounded and resist that change if there is pressure to change?
I'm a simple man. I don't need much, don't have much, don't want much. Number one, when I became Senate President, if y'all recall when Senator Byrd died and Governor Manchin became Senator Manchin and Senate President Tomlin became Governor Tomlin, and I became Judiciary Chairman to Acting President, and I moved into Earl Ray's office. Didn't change a thing other than the pictures on the wall. Put up my family instead of his. I don't need much. I won't change much. You know, I buy my furniture when I went back to my law firm. Got a couple of my law members here. You know, got me a new couch in my office. Got it off Attic Pickers for $350. I won't need a whole lot of money or a whole lot of resources to make the office work. Quite frankly, leaders lead, and they should lead by example, and they show others how to do it. And you live within your means. You live frugally. And you know, I think some of the excessive spending that has been so public here and so criticized will eventually, you know, fall out of the headlines, and folks will then look and see who is, after November 6th, is elected to that office and who is sitting in those offices and what they're doing. And if there's excessive things that happened, I guarantee it'll be under a microscope. You know, I may bring my own pens from home. You know, you're not going to waste any money. I assure you, I'm not. So, you know, that's my answer. With 30 seconds to spare. I saved 30 seconds even already.
Could I have it?
Ms. Smith, judges and justices don't work in isolation. They also hire clerks to assist them in their work. What qualifications or characteristics would you look for in hiring members of your staff, and in particular your law clerks?
Well, I would obviously want to look for someone who had excellent writing skills and who was a very thorough researcher, and one who likes to talk over the issues. I mean, I'm one of those kind of dorky lawyers that, even though I've been practicing for 22 years, I like doing my own research and I like doing my own writing. I mean, that is my ideal day, is sitting at my desk researching and writing. So I'm going to be active in every single case that's written, and I will be assisting in the writing of it on those that, you know, that's because that's what I love to do. But I'm going to have someone who has intellectual rigor, someone who understands the role of the court, understands the law, and someone who is willing to parse things out and think about every angle of an issue, because oftentimes, you know, what you first see to be an issue in a case that comes before you, what your first look at the law, when you delve deeper and you think about it deeper and you continue to mull it around and consider the arguments of counsel, usually it's far more nuanced and far more complex, and it needs to be addressed far more thoroughly than when you first put your head to it. So those are the type of characteristics I would like to have in a law clerk.
Another question from Mr. Sheehan, and this is again in that area of trust for the court. And so my question is, will the people of West Virginia ever trust the state Supreme Court again? And what can the court do as a whole, to rebuild that trust?
Well, the court needs to speak as much as it can with a single voice. I remember reading about former Chief Justice Taft, who said that he occasionally voted against his own conscience in order to mask the court to generate more thorough opinions. A 6-3 is better than a 5-4, a 9-0 is the best kind of opinion altogether from the U.S. Supreme Court. That was kind of his view. I won't say that I would give up my views to mask the court, but I do think that it is important to all speak with a single voice. When I was interviewed by the Judicial Nominating Committee, one of the things I stressed was collegiality among judges. I have to say I was a little appalled in reading about the recent federal trial in federal court about justices attempting to make reports about each other to federal authorities. I could not imagine how a court was functioning under those circumstances. But I think what collegiality means, and the rule change that I think is important, is that instead of issuing opinions separately, we often see cases where a dissenting opinion comes out a couple weeks after the majority opinion. And the problem is we're one of the few courts that does it that way. By having all the opinions come out at the same time, people can revise their views. There was a case this year. I had tried the case. I did not handle the case on appeal. The issue on appeal was whether I had diligently looked for a witness or not. The majority said I did. But there was a question by one of the justices, ended up in a dissenting opinion, about what was the proper standard of review. And quite honestly, I think it was a question that could have been answered by 3 or 4 additional paragraphs in the majority opinion. And you'd have had a better opportunity for the court to be a 4-to-1 instead of a 3-to-2 and speak that way. And I believe if you write with clarity and with confidence and tell the public how it's going, you'll get the results you want. Thank you.
Mr. Schwartz, Mr. Jenkins previously asked you about the advisability of an intermediate court. I have a more broad question to ask you, which is, how do you define injustice, and how will you confront injustice as a member of the West Virginia Supreme Court of Appeals?
In thinking about injustice, I'll go back to sitting in that Baptist church and listening to a pastor talk to his congregation about voter rights and how they're losing voter rights, how throughout this state and in the country, we have more and more barriers being put up for preventing people from easily getting to vote. And that's part of what he was talking about, I believe, when he said, justice is not blind, she peeks. And there's certain members in society, I guess I've been fortunate, I'm not one of them. You know, my blue eyes, white male face opens doors for me, and it always has. And I know that. My Washington and Lee law degree opens doors for me. So I don't face the injustice of a lot of people. And maybe, you know, maybe that makes me kind of elite or something, that I may not appreciate that, but I grew up. My wife is from West Virginia. That's how I got here. I've lived here 30 years now, and I grew up in Queens, New York, born in Mineola, in a very mixed society with friends from all races and ethnicities, and I've seen injustice. My sister is a vice president of Cisco Foods. I saw her work her way up, and I saw the harassment she had to deal with. So I believe that I bring a sensitivity to justice. Justice, in my mind, is fairness. Injustice is very simply unfairness. And if people don't believe that they're going to be treated fairly in our court system, then we have no hope. No hope in our legal system and no hope in our economic system. I hope to bring back some hope.
A question for Jim Douglas. Give me an example of how you've been a good steward of public funds.
Well, I was prosecuting attorney in Braxton County. We had to handle budgets and propose budgets for the expenditure of county funds. And of course, we had to build into it pay raises so that people can feel appreciated in your staff. But we had to justify what we had to do and submit to the county commission. Also, as a family court judge, I think I've been a good steward in this respect. When I first came in January of 2017, I did not have a lamp on my desk, when I'm talking about my bench, and I'd asked the Supreme Court through the proper channels for one, and they had said to me after a couple of inquiries, well, no, we can't do that. Some of us here at in the sports staff have brought ours from home, bring a lamp from home. So as a good steward, I brought my lamp from home. But then later, whenever they gave us our P cards and said that we could make those purchases, I bought a lamp. So I still got the same lamp. I think I've made 4 acquisitions since I've been family court judge in terms of the property. And one's a fan, and like I said, one's a lamp. One was an extra robe, and I think the other one was a coffee maker. So that's all the money I think I've spent on hard items. Gosh, I probably got 60 seconds extra.
Mr. Thompson, you spoke in your opening remarks about your experience. What is your philosophy on judicial activism, and what effect should judges have in setting or promoting public policy?
I think judicial activism can be defined in 2 ways. The first of all is judicial activism and how you rule on cases. And I think judges do not make laws. That's what we have legislatures for. Judges should rule on laws. Judges should interpret the law. Judges should not make law. However, there's also judicial activism when I see problem solving. Sometimes the courts are the first part of government that will actually deal with the problems that society faces, such as we're talking about our current foster care crisis, such as we're talking about the fact that we're having children who are being abused and neglected and not getting taken care of. So in that part, I do think a judge should be proactive, should actually try to fix the problem, should try to look for solutions, should not accept the status quo, should look in ways to make both their litigants, their community, and their state better. And I think that's very important. I think that a lot of times people don't get the opportunity to deal with their government. What we have as a judicial officer, I do get the opportunity to deal with people on a daily basis. And I should strive, not only, if it's a legal issue, I rule on a legal issue. If it's something I can make better for them, such as getting them rehabilitation that they might need. And sometimes it's as simple as, this is hard to say in 2018, but we literally have kids who starve. Making sure kids get fed. There's been times where I've sent out and bought a Big Mac or something of that nature and make sure a kid's fed that comes in front of me. So we do need to be an activist in that. We do need to be an activist in solving the problems of our society, and that's my answer.
This is a question for Mr. Frank, Robert Frank. Every candidate, most, have said how they want to restore integrity to the court. How are you different from the rest? I don't know that I am different from the rest. And I answer it for that reason, for a very specific reason. Everyone up here is committed to restoring confidence in the court. And I'm proud to be among that group. I think the places where I am different are how I approach it. I look at issues associated with restoring integrity, restoring confidence from 2 different perspectives. The first is from my background as a Christian. In my church we study, we teach, we practice a heart of service. And I really think that anyone who becomes a justice of the West Virginia Supreme Court has to have that heart of service. They need to look at each of the problems in front of them as if they are the problems of the people of the state of West Virginia, and they need to approach them in that way. I think the second way that I approach it that might be a little bit unique is I really believe that the constitutional framework provides the court an opportunity to really look at what is right. And what is right is set forth in the state constitution. What is right is set forth in the laws that are passed by the legislature. And when the court takes itself out of a political framework and puts itself in a truly judicial framework where it's not trying to make laws,
It's not trying to choose sides. It's not trying to pick winners and losers. That's when we begin to establish the kind of confidence that the court needs to move forward. And that includes confidence in relation to how we handle the financial matters of the court. But it goes beyond that to fundamental fairness.
My next question is for Mr. Long. We all have people we look up to. We all have role models. Who are two people you admire for their leadership ability and why?
One of my point out would be probably my father. He's been a great role model in my life. I wouldn't be here today if it wasn't for my parents. So definitely my dad is a good role model as a father, as a provider, and I look towards him as one good role model. Trying to think of another good application. It's hard to find somebody sometimes. I definitely, my father, I'm not sure if I can think off the top of my head as another good role model. I am a Christian. Obviously, my faith has a big part of my life. I mean, Jesus would be the other role model, obviously, as a servant. I know we have to be humble, and he came to serve. And this role also has a role to serve in as the government. So thank you.
Thank you.
Question for Evan Jenkins. Recusals or lack of recusals have been controversial in recent years. Under what circumstances should a judge recuse himself or herself from a case?
You know, you look at, there's a number of sources for guidance. One, we've got the judicial canons of ethics and the code of conduct. And there's some pretty, maybe not great bright lines because every fact scenario is different, but there's certainly guidance. So you have to be mindful of that. As a matter of fact, today, sat with my staff attorneys, and we talked about the history of the court vis-a-vis justices and recusing and what types of cases, what are the parameters, what are the guidance. So in addition to the code of conduct, let's also look at the precedent. What has been the past practices of the justices? This is very important. But candidly, at the very core of the issue of recusal is, one, if you've got a clear conflict, absolutely, you have to recuse yourself. The other area is, though, the perception that by continuing on the case, is there a perception from the litigants or the public in general that you may not be able to cast a vote, be able to make a decision on this case in a fair, impartial way. So while you may yourself know that you are not conflicted out, you need to be mindful of the perception that it creates in the public by continuing to sit on that case. So it's very important. Recusal is something we take very seriously on the court, and it's something that I'm candidly very mindful of, and working with my staff attorneys to make sure that I conduct myself appropriately and correctly and within the guidelines of the Code of Professional Conduct for attorneys and judges.
My next question is for Mr. Frank. Mr. Frank, management and budgeting issues are key issues in this election. And if you would, please describe for us your experience and training as it relates to operational management, supervision, and budgeting matters.
Well, like most lawyers, my first opportunity to manage on a daily basis is within my firm. Now, my firm here in West Virginia is me, but over the past, I think, 18 months, we've had about $5 million worth of client funds go through the trust account. And you need to be able to manage those funds because they're not yours. They belong to your clients. And a lawyer's first obligation when it comes to managing funds is to make sure that the client is always protected. In Colorado, I was managing partner of a firm that I think at one point we had 7 lawyers. So it was a larger firm and the same management issues. But it also goes beyond that in that I do a lot of complex business litigation, and when you deal with issues associated with complex business litigation, you have to review and evaluate books. You have to look at spreadsheet after spreadsheet after spreadsheet, and you get used to seeing where the errors are. You get used to seeing the mistakes that people make. I've also served on the boards of numerous nonprofits. I was on the board of the YMCA in Greenbrier County when we had to wind it down because it couldn't meet its financial obligations. I was on the board of the CYAC, the Child, Youth, and Advocacy Center, where we have to set budgets and identify budgets and manage money. I'm on the executive committee of one of the largest churches in the Greenbrier County, identifying how we steward the resources that God has given us. When it comes to management, this is what I think is key. Put your people in a position where they can succeed. If your management style is based on that principle, putting the people around you in a position where they can maximize their effectiveness, you'll be an effective manager. When you fail to do that, you're letting your company down, you're letting your organization down, and you're letting your people down.
Question for Mr. Kessler. Do you support or oppose the constitutional amendment on the ballot next month that would give the legislature oversight of the judiciary's budget? And do you have concerns?
Yes, I support it. West Virginia is an outlier. We're one of the only state in the union that doesn't have legislative oversight of the court budget. My concern is obviously this, if the legislature would use the budget of the court in order to attempt to control decisions before the court by somehow or other crippling the court's budget. That's the concern you hear out there all the time. However, I've yet to see that happen in any other state that it's really become a problem. And I think that's because, there's 3 branches of government, the legislative, the executive, and the judicial. But the judicial is just a little more equal because it gets to ultimately be the final arbiter if the other 2 are out of bounds. And if the legislature would enact a budget and strip the court's budget and say, we're not going to fund the criminal justice system, we're not going to fund the magistrate court system, we're going to reduce access to the court by the public, the court would then have the ability to say, enough is enough. What you're doing is unconstitutional, because under our Constitution, the court does have the ability to be free and unfettered and a separate but equal branch. And I don't see any court, and I certainly wouldn't if I was sitting on it, let the legislature cripple the efficient and effective administration of the court system so that every citizen and business in this state had full and equal access to the court system to have their disputes heard.
Ms. Smith, you spoke previously about the importance of impartiality, but I want to ask you about something that is somewhat related but different, which is independence. How will you balance being an independent judge who is also an elected official?
Well, as a judge, that is your first and foremost duty, to be independent, and that is understanding the constitutional role of the judiciary. I don't see that that's going to be an issue. I mean, it is vitally important for the integrity of a court that you be independent and you remain free of any political agenda, of any political influence, and you must conduct yourself in that manner. I think we have an issue right now with our judiciary where it has become very politicized, and people are starting to believe it is another political body where when they come before the court, their decisions on their cases are going to be made based upon that justice's history of involvement in politics, their prior professed views on various subjects, and they are going to doubt the validity of a decision. When you do not trust that the decision maker is fair and impartial and independent of political influence, then you doubt the result. Then you start to lose doubt, you start to lose faith and doubt in the system. So I think keeping at all times in mind your role as a judge is to put aside your political views, put aside your personal beliefs, and consider only the facts, only the law, and only the Constitution. And keeping in mind that image of blind justice where she has her eyes blindfolded and a scale, and she is weighing the merits and the weights of the case. If you take that duty as a sacred vow, I don't see there's a problem. I don't see there's a problem with remaining independent.
Thanks a lot. And I'm going to ask this the same question I asked Jeff Kessler of Mr. Thompson here about the constitutional amendment that's up for vote.
I have a lot of the same current concerns as Mr. Kessler. We are an outlier state. We're the only state that lets its current Supreme Court set its own budget. I think it's going to pass overwhelmingly. I support it. However, I do have some grave concerns. Some of those concerns are going to be, we have an issue, if you have an issue that the legislature is unhappy with the Supreme Court, what are they going to do? Are they going to punish the Supreme Court? Are they going to take away their, cut, I think it's 15% of their budget they're allowed to cut? That's a very real possibility. Also concerned that some of your legislatures, and this has got, from what I've watched the impeachment trials, I don't think understand how the court system works. And I don't think they understand things such as due process and following court orders and things of that nature. And that somewhat scares me when that's going to be the person who actually sets the budget for the Supreme Court. And it's not just the Supreme Court. Let's be serious here. The Supreme Court is just the entity. It's also going to be setting the budget for the circuit courts, the family courts, the magistrates. And that's going to be a big responsibility. I will say, however, that part of me is actually glad that the legislature is going to take control over it, because we've had some issues in the past when you had some of the administration of the Supreme Court. If you didn't have 3 votes on the Supreme Court level, you didn't get what you wanted, and you didn't know necessarily who those 3 votes were. If it's a legislative issue, say they want to cut a program that's not performing well, we're going to have a public record of how the House of Delegates members voted, how the Senate members voted, and then that's an issue, that will be tried in the public, and we'll know that. So for that, I do look forward to it. I'm just very fearful that it will become, especially given what's been happening lately, become part of a political process.
Mr. Jenkins.
Yes.
How would you handle a situation in which you have become aware of misconduct of a lawyer or of a fellow justice?
Well, you would report it to the Judicial Investigation Commission. We have a body that's charged with the responsibility of taking complaints by the public, by lawyers, and that includes judges and others. We have a code of conduct, and it is important, and we all are bound by it. So this is just simply doing what is right, and that is reporting any infraction, any violation to the Judicial Investigation Commission. They are charged with fully investigating and then proffering up appropriate sanctions if necessary. So I would report it.
For Mr. Douglas, do you believe the state and federal constitutions are living documents that are open to interpretation based on changing circumstances, or do you believe in a more literal interpretation of the documents?
I guess I depart from the herd. I am not a strict constructionist. I believe in judicial activism. All we have to do is look at the history of our republic and we see that it's absolutely necessary. Sometimes the sentiments of the public are not well-founded, or they're fashionable, or they're in vogue, and that's reflected in our legislation and appointment of our legislatures. It's reflected in the election of our governors and presidents. It's what's ever in something that happens to be the issue of the hour, as it were. To me, we have to have judicial activism, because if we don't, we would never had Board of Education versus Topeka, Kansas. We'd have never had the Windsor decision with regard to LGBT rights. We would have never had the Miranda versus Arizona case that had to do with the rights of the criminal defendant. And we'd have never had cases like the Zinger cases, and I realize that was before the adoption of the Constitution. So we have to have bold justices. We have to have justice that's not worried about a popular decision. We have to have justices that are not afraid to think about the impact of a particular decision or a particular ruling. I think it's our obligation to look on down the road to the future. What is going to be our legacy in our government? Not whether or not we'd be reelected for a long term. We have to look to do the right thing. That is the mission of a justice, to do the right thing, and secondly, to do it promptly without fear or favor. I often go back to the quote from Alexander Pushkin that a court must, or a judge calmly contemplates the just and unjust. With indifference he notes the evil and the good, and knows not favor, pity, piety, or wrath.
Mr. Sheehan, in what areas do you believe the average West Virginian lacks access to the legal system, and what steps can the West Virginia Supreme Court of Appeals take to provide better access to justice?
I think the system is largely open. The difficulties traditionally are money. I function a lot of my practice in the bankruptcy system, which has become the modern court of the middle class in America. The poor can get free access to court. The wealthy have access separately. But very often I see people in bankruptcy settings who are just sort of squeaking by and have been taken advantage of. And so I think that there is some idea that we need to have people who have a better understanding. The process needs to be simpler. We have gone to a lot of forms to make people can do their own divorces. I don't think people actually do good divorces by themselves. We don't do, you know, a friend of mine said that the proper answer was to try and get volunteers to help people and not necessarily to get the lawyers out of the system altogether. And what he had recommended was that people who can't afford a lawyer do some charity work and then get a voucher for having done their charity time and present that to a lawyer to pay his bill, so that the lawyer would be free to do some legal work instead of doing the charity work. And that kind of thing gets the lawyer back involved for people who actually need assistance and guidance through the system. I have a lot of people who don't know which end is up, don't understand maybe the civics issues, but still need to have their problems resolved. You know, on the way down, I got one of those phone calls from somebody who was trying to sell me something I didn't want, and I felt like I knew what I was finally going to do about it, but I'm not so sure that other people do. So I think that it's about educating people about what the opportunities are, and that's where I'll finish. Thank you, sir.
Mr. Schwartz, let me ask you the Constitution question. Living documents or more literal interpretation of the document?
Generally, I would say that the Constitution says what the Constitution says. However, having said that, I guess it depends on what part of the Constitution you're talking about. Because we're all human beings, and we all, when we're reading anything, we have an interpretation of what that says. Now, do I believe in penumbra? For non-lawyers out there listening to me, a penumbra is something that you find between the words in the Constitution. It's something that emanates. It doesn't appear in black and white anywhere. I probably have a hard time with things like penumbra, simply because that's too, for the same reason I had a problem with our recent impeachment. It's too amorphous for me. And you have to go to other justices who created the term penumbra. But if Mr. Sheehan and I are both looking at the same section of the Constitution, we may have different interpretations of what the Blackwater law says. All judicial opinions involve the interpretation of the judge making it. So honest, good judges can have different interpretations of the same constitutional provision. So I guess I'm somewhere between strict constructionist and someone who would create a new penumbra.
Mr. Long, most of us have heard of the phrase or the term, the phrase ineffective assistance of counsel. What do you think ineffective assistance of counsel means?
Well, it's counsel whenever they're not doing what they're supposed to do. They're not either advising their client correctly, they're not educated correctly in the law. For some reason, they're not doing right by their client. So ineffective assistance is whenever you're not putting forth a good effort, or you shouldn't probably be practicing in that area, which could lead to malpractice. So that's ineffective assistance. It's whenever you're getting something as a paying client, or even as if you're not paying for that as an assistant, if you're court appointed and you're not getting what you think is correct assistance by your attorney. And if you're not doing that, that's a problem. Thank you.
Question for Mr. Thompson. Give me an example of how you've worked with others to reach a decision. This might be tough for a circuit judge, even if you didn't agree with the outcome.
As far as an example of that, I'm a big believer in people resolving their differences with some guidance. We have a mechanism that's available under civil law in the state of West Virginia. It's called mediation. And mediation is where parties will get together and they'll have a trained person, it's generally a lawyer, who generally has a lot of experience, and they'll work with the parties, and the mediator is supposed to be unbiased and not really have an interest in the result of the outcome. And they'll work with the parties as far as coming up with a resolution or a settlement. I do something similar in my court, and we call them settlement conferences. And I don't do that unless both sides ask. And I really have no desire or no interest in the outcome of the case. It's just whether or not the two parties want to get together and see if there's a way of crafting a solution to the problem. I actually really enjoy that. I enjoy listening to the party sides, listening to what they think the strengths of their case are, and give them, I've got to be careful, I mean I can't cross lines, I'm not a mediator, but listening to what they have to say, what they think the strengths of their case are, and seeing if, with a little bit of encouragement from the court, that a solution can be reached. And I will tell you, a lot of times just having people get together and talk, having people air their differences, that's a good thing. And people will actually a lot of times think about the fact, I've got to come, I've got to air my grievances, and the other side got to listen to me. And then they come up with a solution. So that would be my best answer to that question.
Mr. Jenkins, I'm going to ask you a related question that follows up on that last one about alternative dispute resolution. Are you in favor of increasing the use of alternative dispute resolution in our legal system, or do you see that as potentially dangerous because it interferes with the creation of law and legal precedent?
You know, actually it's in the creation of law that alternative dispute resolution systems actually has been proffered, and legally defining whether or not in certain circumstances those types of resolution matters will be permissible. I am certainly open to the idea. I want to improve the access to the judicial system. I want to reduce the costs associated with litigation. I think that we need to work better about having ways where parties can come together and resolve their disputes. Wouldn't it be great if it doesn't have to take a filing of a complaint to sue somebody to get the resolution that you need? So the concept of alternative dispute resolution, we have it in so many areas of society today, and relationship between consumers and businesses, or between businesses and between consumers. So I think it is important that we do look at and allow the legislature to consider statutorily those sorts of permissible ways. We need to get people together to resolve their disputes in a very efficient way, and that includes a very cost-effective way. And I think this is certainly an area that affords and makes that happen.
It's the final question, I'm told, before the final statements, and this will be for Denise Smith. And in working where I work and doing it for a long time, usually the best employees are those who work hard. Give us some example of maybe your upbringing or your background, and if where you would consider yourself, if you do, a hard worker.
Well, I do consider myself a hard worker. I think most people that go to law school are kind of type A hard worker people by nature. But I mean, I was raised to where in my home I was working as long as I could remember. I was either mowing the grass or babysitting. When I was old enough to answer the phones and do filing, which was probably in an appropriate manner and didn't sound like a 13-year-old, I was moved into my dad's office to work there after school and in the summer. In the practice of law, even now, I work weekends, long hours. I mean, when you love what you do and you love the law and the intellectual pursuit of law, the intellectual discussion of law and thinking about the law, the long hours are something that slip by you. But my nature is, everything that's worth doing is worth working hard for, and justice is worth working hard for. So.
Thank you very much, and thank the panel so far. Now we're going to move to the phase of our forum, which will conclude us, and that is each of the candidates will have 2 additional uninterrupted minutes to state their position relative to their candidacy, and that again will be at random, chosen by the panel. And Dean, would you choose the first person who will conclude?
I'll be happy to. And first we will hear from Jim Douglas.
Thank you, Dean. First of all, I'm nobody, no one, but if anybody wants to know anything about me, it's in Douglas 4, the number 4, Justice, little play on words.com, if you want to see it. Everybody up here has been doing I have beens or I've dones, and I'm just as guilty of that. I've been a past prosecutor, defense attorney, special ed lawyer. I clerked for William M. Kidd, who eventually became federal district court judge in Sutton. Proudest moment in my life probably is when I got a Golden Horseshoe in 1965. But my personal statistics, I've given you statistics of the state and the nation with regard to family law. Let me come back to what Jim Douglas has done as family court judge and why there should be a family court judge or practitioner on the West Virginia Supreme Court of Appeals. Number 1, right now we have 2 appointed justices on the Supreme Court who have never had a divorce case as far as I know, or a family law case as far as I know. There's 1 suspended justice that never had a family law case or a divorce case or a child custody case. There's 1 elected sitting family court or justice that's not had a family case. And all those statistics I gave you before support that. I have collected child support since I've been family court judge up through August of $87,000 plus. Collected it. Went through my court. I've conducted over 30 CLEs in family law and other areas in my career. I have made 20, I guess to be more like 28 years of practice of family court in this state. And I have argued more cases in front of the West Virginia Supreme Court of Appeals than probably anybody on this panel, maybe all of them combined. I've had over 40 cases argued to the Supreme Court. I'm the only family court judge running. We have to have somebody up there for the next time period. And I had the first Saturday court here in Kanawha County over the objection of then Chief Justice Laughrey, and I take care of kids' LGBT rights. Nobody else can compare in those qualifications. Thank you.
Jeff Kessler.
Thank you. You know, everybody on this stage, every single one of them is an attorney. Every one of them got a law degree, knows legal theory, studied the same cases. What sets me apart from the others is the unique experience I have in actually practicing law. You know, the law isn't a means in and of itself. It is a means to an end of a just result of resolving disputes and helping people in your communities and solving problems for people in your communities. That's what I have done my entire life, whether it has been in the legislature for 19 years or whether it's been in practice of law for 37 years. I'm probably the only person on this stage. I was a prosecutor 17 years, city judge 5 years, municipal judge 16 years, you know, all those things. I may be the only person ever put a man in prison for the rest of his life for murder, for rape, for things of that nature. But I've also had the compassion to understand that 80% of the criminal element really don't need locked up. They usually have a drug or alcohol addiction problem that needs treated. And I applaud Judge Will Thompson down there for the excellent job he's done in drug court. I frankly have opened, I was proud as a legislator to fund the very first one in the state. So I can tell you that they do great work. If I am fortunate enough to get sworn in and to win this election, I can tell you what I'll do. I'll drive to Charleston, I'll pack my bags, I'll take the oath, I'll go to work, and I'll do my job, just like I have every other day. I will be blind as to the color of your skin, your gender, your sexual orientation, whether you are rich or poor or powerful or connected. You will get a ruling, just like I've treated every client in my practice, fairly, based upon the facts, the law, and with the dignity and respect that you deserve. And that I can assure you, and I will take that oath right here before you today, that you are going to get that result with me.
William Schwartz.
Thank you for having me. And again, I'm Bill Schwartz. And for 30 years, more than 30 years, I've been in courts throughout the state of West Virginia, doing what I committed myself to do when I was on that moot court board at WNL, when I coached that mock trial team, to be a lawyer in the courtrooms. I know what it's like to hold the hand of a widow and tell her everything's going to be okay. I also know what it's like to advise a small business just trying to get by, and all they want is to be heard, and all they want is fairness when they go to the court. Now, I made reference earlier to what happened in that Baptist church, and there's some people that don't think there's fairness in our court system right now. We can only get there by taking action in several ways: predictability, recusal at even the appearance of impropriety, and respecting the taxpayer dollars. Specifically, what I believe happened in the last administration was lack of control of a court administrator. An important part of the job for anyone coming in is to have the right court administrator, to have control of that budget. And if people think that you have control of the budget, and if people think that you're going to follow those other three, that we have predictability again, I think there's hope. I think the best days of West Virginia can be ahead. I think we can get off the national headlines that we're a state tearing itself apart. And I'd like to be part of that. I'd like to earn your vote. I'm committed to the law. I am a lawyer first and foremost, with deep respect for the law. I am not a politician. I told you why I got into this to begin with. I was embarrassed. I don't want to be an embarrassment to you. I don't want anyone else to be an embarrassment to you. I want you to help you fix this. Please give me your vote. Bill Schwartz.
Next up, we have Will Thompson.
All right. There's been one candidate in this race that's been recognized by the White House for their work with drug courts. There's one candidate in this race who's had the John F. Kennedy School of Government of Harvard University come to study their program. There's been one candidate in this race who's been profiled by the NBC Nightly News for their work in saving their community. I'm not a very good politician because I'm very humble. I do not like to brag on myself. What I'm hoping for is that the people of West Virginia, that the voters of West Virginia will take the time and look and think about and vote for the most qualified candidate. That is all I ask. I'm not going to even necessarily ask you to vote for me. I'm going to ask you to vote for the most qualified candidate. And I'm going to ask you to take a couple minutes and actually look at the accomplishments of the different candidates. This is a very distinguished panel. But I'm going to ask that you look and vote for the most qualified candidate. I think one of the reasons I'm running is because I've seen the problems that face this state. I've seen the children that go hungry. I've seen the children who are not being taken care of by their parents. And I want to do things that I've done in my own community. I want to take that on a statewide level. One of the best testaments I think I can give is that when I was originally appointed as a circuit court judge, there were several candidates for that position. I have stood for election twice. I've ran unopposed both times. There's a reason for that. I'm not a politician. I'm a judge who cares for people.
Marty Sheehan.
I speak 2 foreign languages. I speak legalese, and I'm looking around and I see a lot of Thais out in the audience, and I'm sure a number of people out there also speak legalese. Second foreign language I speak is bankruptcy. And if you speak legalese, you don't necessarily speak bankruptcy. When I am called by friends of mine who are lawyers and say, what's the outcome in bankruptcy court, I usually know the answer. I'm free with that opinion. I know what the law is. I have been the kind of lawyer as a result of that that other people call and say, would you take a complicated case? I'd like your advice in a complicated case. We don't need people on the Supreme Court who can handle the average case. Most of you could handle the average case. We need someone who can handle the complicated, someone who can unravel a procedural mess, and you know those kinds of cases. Every case I have is a procedural mess. I'm working on a case now where I have 270 campers, and I have had to give notice to all kinds of people and do a bunch of preliminary title opinions just so I can get to a place where I can kind of make a deal. And that is the result of thinking about a problem at some length and trying to understand how it works. I think that you need someone who is cerebral on the court. I appreciate the working lawyers that are running for the Supreme Court. I appreciate the working judges who are running. But I think that what I bring to this election is an intellectual ability to understand the law, an ability to factor out the complicated from the simple, and an ability to see through it in a way that we do justice under the Constitution. And that's what I'd ask you to do. On my website, Sheehan for Justice, today I posted what I'm going to call a dissenting opinion to the Workman ruling that she couldn't stand for impeachment. And if you'd like to take a look at that and see what I'm capable of, please do that. Thank you very much.
Up next is Brendan Long.
Thank you. And thanks for everyone again coming tonight. We're here because we have some budget issues. There's definitely a fiscal issue. I have worked as a court administrator, or not a court administrator, but I have worked as an administrator, and I have worked on budgets. I have worked on my own budget as far as my own law practice. We're going to need somebody in there that can work with the court administrator whenever we have one in place that's going to have to work on these budgets. Most of it is non-discretionary. It's going to be going out for salaries for the way the courts are set up and the way things just have to be done as a day-to-day business for the courts. But in that other discretionary areas where it has hit the fan, as we've seen here in our courts, and got in front of the public. And that's what needs to be looked at, so we're not overspending. There has to be some fiscal policy put in place, some policies and procedures, and that's what the next justices will have to do, and they'll have to sit down and work that out. And I'm asking for your vote, and I would like to be able to do that for the voters of West Virginia. Thank you.
Next, we have Evan Jenkins.
Thank you, Dean, and to the Bar Association, thank you for hosting this. It really has been a terrific evening with a lot of good ideas and discussion. The topic came up multiple times. What's it take to be a good justice? Let me mention work ethic. You know, I was an actively practicing lawyer for a number of years, been admitted to the bar for 30 years, but I've also served in public office. Let me just give you a sense of the last 4 years as a member of Congress. I slept in my office. I don't have a place in Washington, D.C. I sleep each night on a $99 cot from Ollie's Discount. It's about going to work each and every day. It's about rolling up your sleeves when we were wiped out by the floods in late June 2016 and helping people get their lives back on the right track. It's about handling a precious newborn baby that's suffering through the ravages of withdrawal and helping start me, 2 NICU nurses, an incredible community volunteer 3 years ago starting Lily's Place. I was in the White House signing the legislation I helped pass to allow a homegrown program go national. We've taken care of more than 200 precious newborn babies. And helping Wetzel Sanders, a World War II vet that was in Pearl Harbor that did not get his Purple Heart from his injury at Pearl Harbor until last year. It's about work ethic. And what every citizen, every lawyer, every judge needs in West Virginia is somebody who will get up each and every day and work their tail off. And for 3 weeks, I've had the honor to already be getting started serving as a justice on our Supreme Court. We've already decided more than 100 cases just last week on writs and petitions. We've been on the bench. We are rolling up our sleeves. We're getting to work. It's work ethic, and I'm up to the task.
Robert Frank.
17 different jurisdictions. 17 different perspectives, 17 different sets of rules, 17 different sets of requirements, 17 different ways of looking at issues. I've appeared in 17 jurisdictions litigating cases. Not the easy cases, not the run-of-the-mill cases, but the kind of cases where you spend 20-hour trial days, 7 days a week, for 6 weeks at a time, trying the case. They're the kind of complicated cases that you have to work your whole life to prepare for, that you can't just do them out the box. They're the kind of cases and the kind of issues that you see when you're on a Supreme Court. They're cases involving constitutional interpretation. They're cases involving federal preemption. They're cases involving comity. There's cases involving jurisdiction. All of these issues are the type of issues that you don't want to face for the first time when you're on a Supreme Court. You have to have the kind of experience working the large cases, working the complicated cases, and working the cases that take the time. But that's not enough. You also have to work the cases for the single mom who can't pay you. You know, I've gotten multiple pro bono awards for the time that I put into representing people who frankly can't afford someone who tries large cases. And lawyers need to do that. Accessibility to our legal system is the foundation of trust in our court system. And until or unless people feel heard and people have the opportunity to be represented, we won't have full confidence in our court. We need to increase the number of people who are heard, and we need to increase the incentives for lawyers to offer pro bono work. Every lawyer in here is getting 2 credits, CLE credits for being here. Maybe they could get those credits for pro bono work. Thank you.
And for our last closing statement, we will hear from Denise Smith.
Thank you, everyone, for your time tonight. Again, my name is Denise Smith, and in my law practice, I've represented coal miners, I've represented coal companies, I've represented secretaries, CEOs, local agencies, state agencies, large corporations, small corporations, and small employers. I've done appellate work on the state and federal level. I'm licensed to practice in Ohio and California. I've handled civil rights cases involving the First Amendment and Fourth Amendment, and employment law cases involving civil rights. I'm running because I love the Supreme Court and I love the judiciary. I agree with William Rehnquist when he said that the judiciary is the crown jewel of democracy. We as lawyers have to protect this crown jewel of democracy. Right now, it is at risk because it is at risk is being taken over by political agendas and career politicians who are coming in with their own agenda on the court. This is an insidious problem that we have to address. The Supreme Court is not a branch of government to be conquered and made to submit by the legislature. It is not a political playground of the governor. We must protect the integrity of the Supreme Court. We must make sure that we have one branch of government that is free from divisive politics. One branch of government where facts and law and the Constitution matter. We have a duty to protect our judiciary. So when you're determining who to choose and who to vote for in this election, don't think about who you're going to vote for your client. Think about who you're going to vote for who's right for the judiciary, who is going to instill trust and faith in the judiciary, who you can believe is going to give a fair and impartial hearing to everyone, one where the litigants and the parties will have faith and trust that they have been heard, that they have had their day in court, and that their case was decided upon based upon the merits, not on their money, not on their political connections, not on special interest agendas, race, color, sexual orientation, or any impermissible factor. So I'm asking you for your consideration. I'm on Facebook. Check me out there and give me a like, and thank you so much for your time tonight.
Well, that will conclude the active part of our forum. On behalf of the Bar Association, again, I'd like to thank deeply all of our candidates. It's a rare occurrence that candidates for statewide office agree to appear on live television and answer questions that you've not seen and not previewed, in which no one else has had any input into the formulation. I'd also like to thank our panel, and while we ask that everyone defer their applause during the presentation, I think now would be a good time to thank all these folks for what they've done here this evening. Now, we want to give these statewide candidates a chance to do a little politicking, of course. So we have a reception out in the Grand Hall. There's food, beverage, and the candidates will be there to meet and greet and speak with those of us who are present tonight. Thank you again very much, and that concludes our forum. Thank you.
Thank you.
Okay.